Hello and welcome everyone. A very warm welcome to every single person who has joined us today. A very sincere gratitude to Shri Asim Pandya sir
Thank
for
you.
being with us and for extending to us his bits and pieces of knowledge that are so valuable to all of us. And in that respect, I want to, first of all, without taking much time of everyone, just introduce Asim sir. Asim sir is a senior advocate. He is a former president of the Gujarat High Court Advocates Association. He is also the founding partner at Asim Pandya and Associate. He is the author of many books on which we also wanted to speak, and hopefully we'll have some time to speak with Sir on. So these include the writs and constitutional remedies, law of contempt of court, law of bail, rights of arrested persons, investigation and bail, excise law and procedure, writs. He writes articles in law journals. He is a visiting faculty in several law colleges. Very interesting thing about Sir is that he is a hobbyist and he has gotten a bronze medal in Ahmedabad badminton tournament. He's participated in All India Veteran Badminton Tournament at Goa in 2021. He plays the tabla, keyboard, and is fond of Indian classical music. His music direction in Gujarat anthem is appreciated by all, and he has directed music in Namu Tane Hun
Gurjari. Namu Tane Hu Gurjari means
Namu Tane Hun.
I bow down to the motherland Gujarat.
And
Namu
sir, that is
Tane Gurjari.
evident in your actions, and we're grateful to you for your service to not just the country, the motherland, but also to every single intricate detail of it. Sir has also previously spoken to us on the on Article 226, the Constitution of India, myths and misconceptions. So today's topic for class, as I understand everyone is aware, is the relevance of CPC in Article 226 proceedings. So with this, I will very humbly want to hand over the class to everyone and welcome everyone. I'll just very humbly want to just also mention that whatever questions are there, I request everyone to kindly keep them for the last for a question and answer session with sir. And sir, I welcome you and I hand over the class to you.
Thank you very much. First of all, good morning to everyone who are present in this webinar. The topic is really very interesting. The topic is whether the provisions of Code of Civil Procedure 1908 would apply to the proceedings under Article 226 of the Constitution of India. The subject is of great practical importance because when you join the profession or if you are already in the profession and practicing in High Court, various kinds of issues arise during the practical practice. I am getting my own echo.
I request everyone to kindly just mute their mics.
Hello. Yes. Yes. Now I think it's okay. So during practice, these kind of issues frequently occur in the court proceedings, and therefore it is necessary to have clarity on this issue. Before I move on to the topic, let us understand, of course, in the topic where myths and misconception of Article 226, I had elaborately stated the width of Article 226. But those who are new to this webinar or those who have not watched the earlier lecture, I would just briefly describe the nature of Article 226, the width of Article 226, and then we will move on to the real subject of today's discussion. First of all, let me point out that most of us have an impression that the writ jurisdiction, which is Article 226, was possessed by all high courts prior to the Constitution of India. So we must understand now it clearly that it is not correct. Originally, only 3 high courts, namely High Court of Judicature at Bombay, High Court of Judicature at Madras, and High Court of Judicature at Fort Williams, Bengal, that is Calcutta High Court, possessed traditional writ jurisdiction. Other high courts that were established under the letters patent were not possessing this kind of writ jurisdiction. And the jurisdiction which was possessed by only these three chartered high courts, namely Bombay, Madras, and Calcutta High Court, was also very limited. They had jurisdiction to issue traditional writs within the presidency towns only. So writs would not go beyond the territorial jurisdiction of the presidency towns. So let us be first of all clear that this jurisdiction which we are going to discuss, Article 226, in the context of applicability of the Code of Civil Procedure, is entirely a new jurisdiction not possessed by any court prior to the Constitution of India. So this is the little historical aspect. Now let me point out what is the provision of Article 226 so that the discussion becomes very clear. The text of Article 226 is that notwithstanding anything in Article 32, every High Court shall have power in relation to the territory in which exercises jurisdiction to issue to any person or authority, and in appropriate case, appropriate government directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, certiorari, and quo warranto, or any of them for enforcement of the rights conferred under Part 3 of the Constitution of India or for any other purpose. So, if we examine the text, it is very clear that High Court is given jurisdiction to issue directions or orders and writs, including writs. So it is not limited to writs. So we for convenience describe it to be a writ jurisdiction, but it is much wider than the writ jurisdiction. So that aspect must be clearly borne in mind, that the jurisdiction of issuing traditional writs in a modified form is only a small segment of the very wide jurisdiction under Article 226 of the Constitution of India. Now, let me just broadly point out what is the nature of this jurisdiction. So, if I am to describe this jurisdiction in one sentence, I would say that it is a jurisdiction of judicial review to enforce the rule of law in all governmental or other individual actions which has a ramification on public. So, in one way, we can say that it is a public law remedy. But if we examine, it is not confined to only public authorities or government, but in a given case, if the individual action affects the public at large, then it is available against the private individual also. Recently, I think Honorable Supreme Court has clarified this aspect in the judgment in Kaushal Kumar's case, that petition under Article 226 is maintainable against a private individual also. Two just examples. Suppose you are running a restaurant and you are disposing of your kitchen waste in an open land, and it is causing trouble to the neighbor or any person who is residing in the same area. He is entitled to file a petition against that private individual restaurant owner also, saying that he should comply with the provisions of waste disposal management rules, and he cannot throw kitchen waste in open, and a writ against private individual will be maintainable. So this is one instance. And earlier also I said that suppose you are running a theater and you say that I will not allow a person of a particular caste to enter into this theater, then you can also file petition against an individual owner of the theater, saying that it violates Article 15 sub-article 2 of the Constitution of India, whereby it has been stated that any place which is thrown open to public, you cannot restrict entry on the ground of caste, sex, religion, etc., etc. So this is the width of Article 226, and please do not confuse it with the original traditional writ jurisdiction, because as soon as you describe it to be a writ jurisdiction, you bring all technicalities attached to the original traditional writ jurisdiction into our jurisdiction, which is absolutely unwarranted and uncalled for. Now, let us understand what is the nature, whether it is nature of this jurisdiction, whether it is ordinary civil jurisdiction, whether it is an appellate jurisdiction, whether it is a revisional jurisdiction, or whether it is an extraordinary jurisdiction. So it should be made clear that it is not an ordinary civil jurisdiction as understood, where civil courts or high court is exercising original jurisdiction, deciding lease between two private individuals, means private disputes, because there are many high courts that are conferred original jurisdiction to try suits also, like Bombay. So this should not be confused with the ordinary civil jurisdiction. Then is it an appellate or revisional jurisdiction? The answer is emphatic no. It is not an appellate or revisional jurisdiction. Then question would arise, then is it an extraordinary jurisdiction? Then also again there is likely to have a confusion, because letters patents issued by British Crown when the high courts were established in India, they confer extraordinary jurisdiction on high court to withdraw suits from the trial court and try itself. So that is, in the sense of the letters patent, it is an extraordinary jurisdiction. So one should be very clear that it is not even that kind of extraordinary jurisdiction. Then how do you describe it? So I would, if I am to say, then I would say that this is a special jurisdiction, special constitutional jurisdiction of original nature. Let us be clear that it is a special jurisdiction. So it will not create confusion with the extraordinary jurisdiction under the letters patent. So it's a special constitutional jurisdiction and of original nature, because most of the time the parties approach the high court directly without taking recourse of the trial court or other courts or tribunals. So this is in that sense original jurisdiction and special jurisdiction, because no other court possess this kind of jurisdiction. So even if you compare this jurisdiction with the jurisdiction of the Supreme Court under Article 32 of the Constitution of India, the Supreme Court jurisdiction is also not akin to Article 226. The Supreme Court's jurisdiction under Article 32 is much narrower than the jurisdiction of the High Court under Article 226, because under Article 32, the Supreme Court has jurisdiction to issue appropriate direction, orders, etc., for the enforcement of fundamental right only. There are judgments to the effect that when you approach the Supreme Court, since it is an issue of enforcement of fundamental right, the petition under Article 32 would not be maintainable against private individual. But there are so many instances, and I gave these two examples, where even a private individual can also directly approach Honorable Supreme Court under Article 32. The only restriction is, or only condition is, that you should come out with a grievance that your fundamental right has been violated. Whereas if you approach the High Court, it can be remedy of Article 226 can be invoked for any other purpose also. I am not going much deep into it because that's a separate thing, and I think I have already spoken about all these things in my previous lecture. So I'm not troubling you with the same thing again, but this is just a brief background so that we understand today's topic in a proper sense. Now, coming to this aspect of CPC, whether how far it is applicable. If I state simply one thing, then the discussion would be over, but there is no end to that, because the provisions of CPC, section 141, provides that whenever parties are governed or parties are approaching civil court or any other court, then the provisions of CPC are to be made applicable as far as they can be made applicable. So in any court which exercising civil jurisdiction, then the provisions of CPC is made applicable as far as it can be made applicable. So prior to amendment in the CPC, this was the position prior to 1976. But in 1976, there is an amendment in section 141 of Code of Civil Procedure. Prior to 1976, there were divergent views of different high courts. And some high courts said that civil procedure code will be applicable to proceedings under 226 also. Some courts took the view that it would not apply because it would defeat the very purpose, because the nature of jurisdiction under Article 226 is a very summary remedy, summary, quick and inexpensive remedy. So when we approach the High Court under Article 226, the issues are decided on affidavits. Parties are not allowed or permitted to lead evidence. Parties are not entitled to examine or cross-examine the parties or witnesses. So it avoids elaborate procedure which is available under the Civil Procedure Code and Evidence Act. And if you see the provisions of the Evidence Act, Section 1 itself makes it clear that the provisions of the Evidence Act will not apply to the affidavits. So once that is made clear under Section 1 of the Evidence Act 1872, it is obvious that when High Court proceedings under Article 226 are decided on the basis of affidavits, there is no question of leading evidence. And therefore, it is a summary remedy where it is possible to give relief to the parties based on the affidavits of the parties. Similarly, once this explanation which was introduced from 1st February 1977 in CPC, because as I said that there were divergent views of different high courts. Therefore, to clarify this issue, in 1976, the amendment was brought and explanation was added to Section 141, which says that the procedure contemplated in Civil Procedure Code will not apply to Article 226 proceeding. So the controversy was set at rest by introducing this explanation in Section 141. So I said that once this is clear, why should we have discussion on this issue at all? Is there an end to the discussion once this explanation is borne in mind? My answer is no, because still the controversies keep arising in all courts, and all courts had to deal with various issues pertaining to the applicability of Civil Procedure Code to a proceeding under Article 226 of the Constitution of India. Now, first of all, let me just point out that there are High Court rules in each High Court. So, to what extent the provisions of Code of Civil Procedure 1908 will apply partly depends on the rules of High Court also, each High Court. If I speak about the Gujarat High Court, I will be in a position to point out that there are several rules which make provisions of CPC applicable to the proceedings under Article 226 also. The first instance is Rule 84 of the Gujarat High Court rules, which say that the provisions of Order 41 pertaining to appeal, regular appeal, would apply to the provisions of letters patent appeal also. So letters patent appeal arise out of the orders passed under Article 226. So to that extent, the High Court rule of Gujarat provides that the provisions of Order 41 pertaining to appeal will also apply to the letters patent appeals that are filed under Clause 15 of the letters patent. Now, an interesting issue arose in Gujarat High Court. One day, one counsel appearing on behalf of the appellant in letters patent appeal was absent. and the court wanted to proceed with the appeal on merit and wanted to dispose of the appeal on merit. At that stage, the learned counsel appeared and said that you have no authority or jurisdiction to decide the appeal on merit, because if you examine Rule 84 of the Gujarat High Court Rules 1993, it says that provisions of Order 41 will apply to the letters patent appeal. And Order 41 Rule 17 says that if a party or counsel is absent at the time of hearing of the appeal, then the court would be entitled to dismiss the appeal for want of prosecution, dismiss for default, but the court cannot proceed on merit. So arguments were canvassed by the counsel that once by virtue of Rule 84, the provisions of CPC are made applicable, you are not entitled to proceed ex parte on merit, and you have only option of dismissing the petition for default only. The Supreme Court, means Gujarat High Court, examined the relevant provisions, the historical aspects, and the width of the jurisdiction, that it is a special jurisdiction. And ultimately, the High Court said that though Rule 84 might be providing that provisions of Order 41 would apply to the letters patent appeal, but letters patent appeal being a part of the original jurisdiction, special jurisdiction conferred under the letters patent of a particular high court. Therefore, when appeal is arising from the proceedings under Article 226, we will not read the provisions of Order 41 into such proceedings, because they are special procedure and these are constitutional jurisdiction that cannot be curtailed or circumscribed by the rule-making powers of the High Court. So it is very interesting issue, and I may just give citation of that. The judgment is District Rural Development Agency, Baroda versus Naresh Kalidas Patel, which is reported in 1998, Volume 2, Gujarat Law Herald, page 663. It's a 2 judges bench judgment, and both the judges later on became the Supreme Court judges. I think one of the judges was Justice Balakrishnan and another was Justice J.M. Pancha. So both of them refused to apply Order 41 to the proceedings under letters patent appeal. Then Rule 175 of the Gujarat High Court rule provides that if a party wants to file a petition in a representative capacity, then the procedure under Order 1, Rule 8 of Civil Procedure Code will apply. So if you intend to file a petition in that capacity, representative capacity, by virtue of this Rule 175, it has been made clear that the provisions of CPC will apply mutatis mutandis. Then, as I said, that though it is a summary jurisdiction where issues are decided on affidavits, but still there is a very interesting rule, that is Rule 185, which permits the High Court, while exercising jurisdiction under Article 226, to record oral testimony of a witness. It also provides for issuing summons to the witnesses, and it has made clear that when such a thing arises, the procedure of civil procedure code will have to be followed. So whatever procedure which is applicable to a ordinary suit proceedings can be followed by the High Court. So that is Rule 185. Then Rule 186 of Gujarat High Court rules. So I must make it clear that if you want a clear answer to this issue which we are discussing, you must examine the rules of the High Court where you are practicing or where you are concerned with. So without that, you will not get a clear picture. And of course, despite those rules that may be in force or that may have been enacted by a particular High Court, you can still argue on the basis of the judgment in that what I said, that District Rural Development Agency, Baroda versus Naresh Kalidas Patel, that despite the applicability of the rules, they are not strictly applicable and they serve as guide only. So that is an argument open to you for on the basis of this judgment. So please examine the High Court rule where you are practicing. Without that, you will not get a clear answer. So now coming to Rule 186 of the Gujarat High Court rules, which provides that when there is a difference between the views of two judges on a bench, then that dispute or differences will have to be resolved through the procedure which is contemplated under section 98 of CPC. So procedure in a case of a difference of opinion between judges in a bench to be decided in accordance with section 98 of CPC. So here again, the rule provides for applicability of CPC. Then Rule 189, 190 and 91 of the Gujarat High Court rules provide that in petitions under Article 226 also, once the petitions are disposed of, the orders are to be drawn as if they were a decrees and executable as if they are decrees in accordance with CPC. So these three rules are very important. Probably in all high courts, there must be analogous rules which provide that when petitions are disposed of under Article 226, orders are to be drawn in the same manner as if they are decrees of the civil court, and they are liable to be executed in the same manner as if they are decrees. So these rules may be borne in mind. And Rule 192 of the Gujarat High Court rules provide that Order 21, Rule 22, which provides that if you approach the executing court after 2 years against assignee of the interest or for any other reason, then a notice is contemplated that before executing a decree or order, the party should be given a notice that why it should not be executed. So under Rule 192, the provisions of Order 21, Rule 22 has been made applicable so far as state of Gujarat is concerned. And Rule 194 of Gujarat High Court rule says that if a petition is filed under Article 227 and it is disposed of, the order made under that on that petition is liable to be executed as if it is an order of the civil court. So execution is also permissible. Now, question sometimes arises that whether a caveat application under section 148 capital A of the Code of Civil Procedure is possible to be filed in a high court in 226 proceedings. So again, you will have to refer to the rules of the High Court. Bombay High Court has recently, I think in 2021, enacted rules which provide that you cannot have a right to file caveat application in the proceedings pertaining to Article 226. I examined the Gujarat High Court rules in that context, and I could not find any specific provision providing for filing a caveat in respect of a petition under Article 226. So once there is a vacuum or there is absence of the provision, it can be safely argued that once section 141 explanation of CPC provides that the provisions of CPC will not apply to any proceeding under Article 226, by necessary corollary, it means that you cannot file a caveat application under section 148 capital A of CPC. So please examine this aspect so far as a particular high court is concerned. This is not a general rule. You will have to go by the rules enacted by a particular high court. So please examine where you practice, whether you are entitled to file a caveat or you are not entitled to file a caveat under section 148 capital A of CPC in respect of the proceedings under Article 226. Now, coming to very important decisions on this issue. First issue that would arise, whether principle of res judicata, because it is also embodied in section 11 of the Code of Civil Procedure, that if a party has filed a case and it is decided on merit, so when there is an issue between the parties which is already adjudicated by a competent court on merits, then another civil suit or other proceeding is not maintainable. So very important issue would arise whether the principle of res judicata, which is embodied in section 11 of CPC, can be made applicable to 226 proceedings or not. And secondly, sometimes after arguing a petition for some time, the party would withdraw petition unconditionally. Then in that event, whether he is barred by order 23, rule 3 to file a fresh petition. So these are two very important issues that are to be looked into, and they cannot be simply answered on the basis of the explanation to section 141, which says that the provisions of CPC will not apply to writ proceedings. So then does it mean that once a petition has been adjudicated upon between the parties in respect of the particular subject matter on merit, a second petition is maintainable? The answer is no. The principle of res judicata, though it is embodied in CPC, but it is a principle of substantial law also. So just keep it in mind that though it is a procedural aspect under CPC, but it is a question of substantial law and public policy also, that parties should not be vexed more than twice in respect of the same subject matter. So once it has been decided on merit between the parties are precluded from filing a second proceeding in respect of the same subject matter and between the same parties or litigating under the same title. So assignee of the interest or subsequent transferee also cannot maintain a second petition. So that is a judgment in Sarguja Transport versus Appellate Tribunal of Transport, that is reported in AIR 1987, Supreme Court 88. And there it is a very interesting judgment where the issue was whether withdrawal of a petition without permission to file a fresh petition, whether second petition is maintainable. So the Supreme Court said that though provisions of CPC may not be applicable in such cases, but it is a public policy and it is necessary that if a person has withdrawn a petition unconditionally, then on the public policy principle, the party should not be allowed to file a fresh petition on the same ground and between the same parties, because that would result into bench hunting. So in a given case, if a judge is against you, you will withdraw it. And since order 23 will not apply to writ petitions, you would file a second petition when bench is comfortable. So the Supreme Court in Sarguja Transport versus State Transport Appellate Tribunal, reported in AIR 1987, page 88, has clearly stated that on public policy, we will not permit a filing of a fresh petition once it has been withdrawn unconditionally. If it is withdrawn with a condition to file a fresh petition, then it stands on a different footing, but it will not apply when there is unconditional withdrawal. But at the same time, the Supreme Court made it clear that when issue of enforcement of fundamental right or liberty of an individual is affected by any action, then in that event, probably the principle of withdrawal under order 23 cannot be made applicable, and the issue was left open to be decided in appropriate case. So in a given case, suppose you move application for violation of Article 21, individual liberty. At that stage, suppose the court says that no, you have approached much prior to the time and there is no cause of action. And by that time, you also argue other points also, and the court has given a judgment. But later on, actual cause of action arises. You might have filed petition on apprehension that a preventive detention order is likely to be passed against you at pre-execution stage. You have approached, and then you have invited the order on merit. Later on, suppose actual execution preventive detention order is passed, then are you precluded from filing a petition on the ground of res judicata? Or if you had withdrawn earlier after arguing it, are you precluded from filing a fresh petition on public policy, which is stated in Sarguja Transport's case, that by implication, Order 23, Rule 3 will apply. The Supreme Court has said that it would not usually preclude a party from filing a fresh petition if it is a question of enforcement of fundamental right affecting freedom of an individual, and this issue is left to be argued in a future case. Now, one very important decision which you must take note of it, that is Arunima Baruha versus Union of India, which is reported in AIR 2007 Supreme Court Weekly, page 4609. Very interesting decision of the Supreme Court, where the party approaching the court did not disclose before the court that he has already availed of an alternative remedy of full-fledged suit. And the High Court, noting this suppression of an important material fact, dismissed the petition on the ground that petition suffers from suppression of fact, and therefore it is liable to be dismissed. Thereafter, a second petition came to be filed. Then the Supreme Court said that whether second petition would be maintainable or not. The Supreme Court said that if a second petition is filed, disclosing all material fact, and party has approached with clean hands, then you cannot simply dismiss the petition on the ground that earlier petition was dismissed on the ground of suppression of material fact. Now parties have come with clean hand, and it has disclosed every aspect of the case. Court may in a discretion say that you have already availed of a remedy of civil suit where all rights would be adjudicated fully, and therefore we will not entertain this petition. That's a different thing. But the court will not be right in dismissing the petition simply on the ground that earlier petition was dismissed on the ground of suppression of facts. So this is when very important judgment, and the Supreme Court said that earlier judgment does not operate as a res judicata, because access to justice is a fundamental right under Article 21. So everybody is entitled to have access to court, and nobody can be prevented from approaching the court if it has approached with clean hands and with complete disclosure of complete facts. And secondly, judicial review is part of basic structure. So once a party is approaching the court with a grievance that some authority has violated his rights, then you cannot refuse that earlier petition was dismissed on ground of suppression of facts and non-disclosure of facts, material facts. So it is part of basic structure also, judicial review, and therefore on these two counts, Supreme Court in Arunima Baruha versus Union of India made it clear that it will not operate as a res judicata. Now, another important judgment is also delivered by a Chhattisgarh High Court. Chhattisgarh High Court, the issue was that when a petition is either dismissed for default and a restoration application is filed, or petition is decided on merit, and party is approaching the High Court with a review petition, then whether the limitation prescribed under the Limitation Act of 30 days, whether that can be made applicable to a review petition or restoration application filed seeking restoration of petition under Article 226 or reviewing the judgment delivered in a petition under Article 226. The Chhattisgarh High Court examined all this judgment and finally came to the conclusion that if you examine the explanation of Section 141, it says that provisions of Civil Procedure Code will not apply to any proceeding under Article 226. So any proceeding, this is my interpretation, of course, this has not been dealt with so clearly in that judgment, but it has delivered a judgment on different footing. But my view is that once any proceeding is mentioned, it would also include a restoration proceeding of a petition under Article 226, which has been dismissed for default, and a review petition filed seeking review of a petition, review of a judgment delivered in a petition under Article 226. So when both these things are covered, the provisions of Limitation Act of filing review within 30 days or restoration application within 30 days will not apply to a review or restoration petition seeking restoration or review of the judgment under Article 226. So this view was otherwise my view expressed in my book in Writs and Constitutional Remedies. Now this is now supported by the judgment of the Chhattisgarh High Court, and you can also take note of that decision, Srimati Jyoti versus General Manager. It is a judgment dated 13th December 2016. So please take note of this judgment also. Then one very important practice which was evolved by Allahabad High Court prior to the amendment in the CPC. It's a judgment of 1967 of Supreme Court of India. Allahabad High Court had evolved a procedure that when a party is approaching High Court with a petition under Article 226 seeking writ in the nature of certiorari, then it will have to be filed within 90 days. And if it is not filed within the period of 90 days, then party must come with an application for condonation of delay. Otherwise, his petition would not be entertained. That was the practice which was evolved by the Allahabad High Court. And when the matter reached Supreme Court in Chandrabhushan versus Deputy Director, which is reported in year 1967, Supreme Court 1272. It has stated that once the jurisdiction of High Court is a constitutional jurisdiction of a special kind, you cannot import the provisions of Limitation Act or Evidence Act or the procedural technicalities under the Civil Procedure Code. So Supreme Court said that though it might have been a practice of Allahabad High Court for so many years, but this practice cannot be exalted to the status of the rule. And on rule making power also, the Supreme Court said that even if such a rule is made, probably it would not be right, because this is unlimited jurisdiction of a special kind which cannot be fettered by a rule making power of the High Court, and rule cannot go beyond the constitutional jurisdiction. And therefore the Supreme Court did not approve the practice of seeking delay condonation application when petition seeking a writ in the nature of certiorari was filed before the High Court. So this is a very important judgment, and most important judgment is that of Supreme Court in Puran Singh versus State of Punjab, which is reported in AIR 1996, Supreme Court page 1092. Please note down this judgment, which is very important, which is a very landmark judgment. Puran Singh versus State of Punjab, reported in AIR 1996, Supreme Court page 1092. The issue was that when during the pendency of a petition under Article 226, one of the parties died, then in that event, whether the parties are supposed to bring legal heirs of the person who has died within a period of 90 days. And if it is not filed within 90 days, whether petition automatically stands abated, and thereafter whether delay condonation application with a prayer to set aside the abatement of the petition will have to be filed or not. The Supreme Court again examined all these previous judgments of Babu Bhai Murji, which was prior to amendment in 1976 in CPC, and examined the scheme of CPC, and finally said that CPC provisions will not apply to writ proceedings, and therefore it may not be necessary to bring legal heirs within a period of 90 days. And party may not be required to file an application for setting aside abatement and condonation of delay. But party at the same time the court said that you cannot ignore the death of a person. You will have to make an attempt to find out who are the legal heirs or legal representative of the person who has died, and you must bring the legal heirs or legal representative on record of the case so that court can fully adjudicate the petition on merit. But on the aspect of procedural aspect, the Supreme Court simply said that you cannot import the provisions of Order 22, Rule 10, or Order 1, Rule 10 in the proceedings under Article 226. So by necessary corollary, limitation will not apply. So let us be very clear that when a petition under Article 226 is filed, the provisions of the Evidence Act are not applicable because they are decided on affidavit, and therefore Section 1 of the Evidence Act clearly states that it will not apply to affidavit Evidence Act and to the arbitration proceedings. So to arbitration proceedings we are not concerned with, but that has been made clear. Secondly, it is a special jurisdiction, and therefore you cannot say that petition has to be filed within a particular time limit, 3 years or 1 year, or for certiorari 90 days. All sorts, this kind of things is impermissible. Only thing is that when party approaches the High Court after a long delay, the party must explain approaching the High Court after a delay. And if there is a reasonable explanation, then court may excuse the delay which has been filed in filing a petition, but there is no need of filing a separate application seeking condonation of delay. So here I would like to make one aspect clear, that a petition cannot be dismissed on the ground that it is time barred. There is no concept of time bar to petitions under Article 226 or 227. Concept of delay and laches is of course there, but that is a different thing than time bar. So when you file a written reply affidavit in a petition, you cannot say that petition is liable to be dismissed on the ground that it is time barred. You will have to make a pleading that this petition doesn't deserve to be entertained on the ground of delay and laches. Party has acquiesced in a particular aspect. They have not been vigilant enough to approach the court within a reasonable time, and therefore it is liable to be dismissed on the ground of laches and delay, not on the ground that it is time barred. So while drafting, you must bear it in mind that is absolutely incorrect to state that it is time barred. And I come across so many pleadings that one pleading you will find that there is an alternative remedy and therefore petition is barred by alternative remedy. Now that is also incorrect pleading. It is a self-imposed restriction where alternative efficacious remedy. So suit is never an efficacious remedy because it takes long time. So you cannot say that suit is always available. So you cannot say that it is alternative remedy is available and therefore petition should be dismissed or petition is barred by alternative remedy. You will have to plead that the petition is not required to be entertained on the ground that the petitioner has alternative efficacious remedy, and you will have to point out that how it is efficacious. So these pleadings on the time barred aspect in petitions and alternative remedy aspect must be borne in mind. So Limitation Act will not apply, Evidence Act will not apply, and by virtue of the provisions of explanation to Section 141, even the procedure envisaged under the Code of Civil Procedure 1908 will not apply. But as per the judgment of the Supreme Court in Puran Singh versus State of Punjab, Civil Procedure Code would definitely serve High Court as a guide only. So you cannot simply brush your eyes, but you can just take out broad principles of the Civil Procedure Code without strictly following it. And as I said, that Supreme Court said that you cannot ignore the death of a person. But the so far as procedural aspect of bringing legal heirs within a particular time limit or automatic abatement of a civil suit when party dies and heirs are not brought within the time limit, those things will not follow in a petition under Article 226. So all three aspects, Evidence Act, Limitation Act, and CPC, are not applicable to the proceedings under Article 226 and even 227 also. Let me just briefly state that what is Article 227. Article 227 confers a power of superintendence on all high courts over the subordinate courts and tribunals. So this power was available to all high courts even prior to the Constitution of India. Just keep it in mind that there was no parallel power like Article 226 prior to the Constitution of India. But so far as power of superintendence is concerned, there were so many, all charter letters patent provided for similar powers. If you examine the Indian High Courts Act 1861, Section 15 of the Indian High Courts Act conferred power of superintendence, which is analogous to Article 227. Then Government of India Act 1915 also provided Section 107, which was also analogous to the current Article 227 of the Constitution of India, which conferred a power on the High Court, power of superintendence over the subordinate courts that were subject to the appellate jurisdiction of the High Court. Now, there was slight difference in the Government of India Act 1935, Section 224 of the Government of India Act 1934, where only it was made clear that power of superintendence would only mean power administrative jurisdiction. It would not cover within its sweep the judicial power of superintendence. So that was a slight deviation from the earlier scheme of 1861 Indian High Courts Act and the Government of India Act 1915, Section 107. So it conferred only administrative jurisdiction over the administrative power of superintendence in the High Court over the subordinate courts. But when Article 227 was enacted, this was debated, and ultimately the position which was prevailing prior to Section 224 of the Governments of India Act 1935 was restored. That is Section 107 and Section 15 of the Indian High Courts Act 1861. So meaning thereby 227 even confers power of judicial superintendence, so not only limited to administrative jurisdiction. So this is, and additionally, earlier it was available over the subordinate courts. So power of superintendence over the subordinate courts. Now word tribunal has also been added in Article 227. So this is an important and significant amendment or enactment in Article 227. So that has been interpreted by the Calcutta High Court full bench in Dalmia Jain Airways versus Sukumar Mukherjee, which is, I think, AIR 1951 Calcutta full bench at page 253. So that is the first judgment which interpreted Article 227. And that is the most important judgment which has been consistently followed throughout, even today also. So 227, it is a power of superintendent. So power of superintendence is again a very different jurisdiction. Power of when power superintendent will intervene when the trial court or subordinate court exceeds in jurisdiction. It does not follow the set procedure. Then in that case, being a superintendent, the High Court is entitled to intervene and set right the things which had gone wrong. So as such, if I may say, it is as such not a power, but it is a duty. It is as such, when power of superintendence are exercised, it is at the instance, it can be at the instance of a private individual, but it is essentially the High Court is exercising power of duty. When subordinate courts or tribunal do not follow the law of the land, they take recourse of a procedure unknown to law. They exceed the bounds of jurisdiction. So only jurisdictional errors can be corrected while exercising power of superintendence. So this is again a unique power. So that cannot be again brought within the parameters of CPC. But while looking at the order of the trial court or tribunal, which is being examined by the High Court as a superintendent, it will have to look into it whether the CPC is applicable to the proceedings conducted by a trial court or a tribunal, and if they are not followed or violated, or procedure unknown to law has been resorted to by the High Court, then to that extent, whether trial court's order is within the jurisdiction or for that limited purpose, court will look into CPC. But power of superintendence itself is not bound by the procedure contemplated in CPC. So I think this is an end of the today's session, and I believe that this information which I have shared with you is will be really helpful to all of you. Thank you very much.
Thank you, sir.
Thank you,
So
sir.
very expansive. Pranavji, please.
Thank you, sir. It was a very insightful session, sir. I'm
Thank you.
so
Thank you.
grateful. We have
Thank
heard
you.
a lot about you, and I'm thankful to Keshav for bringing you on this platform.
Thank you very much. So nice of you. You liked it. That is important, and it will be useful, definitely, I'm sure.
Yes, sir. We have taken notes. I've actually taken down notes of the case laws that you mentioned.
Okay.
Thank you so much, sir.
Now you can open the platform for question answer session if time permits.
Absolutely, sir. Absolutely. So, sir, Sir Sathiji is also a very young, prominent lawyer in Delhi, and hopefully, with your blessings, he'll also be doing. So, we all just look forward to your blessings and guidance in bits and pieces.
Sure.
So, sir, there are certain questions in this slide which have come together. Sathiji, do you have a question that you want to put forward right now?
No. Proceed with the questions that are there already. I'll put.
So, sir, questions again, because you have explored the ambits of the entire perspective of Article 226. So, a few questions are there which are there with me, but I think VGK sir wants to ask something first. VGK sir?
No, actually, I don't want to ask anything much, but the session was very educative.
Thank you.
And for the first time, I have come to understand the 1861 Indian High Court's Act. I mean, I was quite curious with that. And of course, the Government of India Act 1915 relating Article 227 and 1935 also was very, very enlightening. And yes, the Puran Singh versus State of Punjab, that also was really, I'm curious. Perhaps I will have to read the Kolkata judgment also.
Yes.
Very carefully. And I think you'll have to make a repeat, because the discussion was, your delivering was so good. Then it was very eye-catching. It's very something that make us, because we are practicing every day in the High Court.
Right.
And all these things we keep forgetting sometimes.
Right.
But I think we have to continue with this subject once again. Mr. Sharma will have to see to it. And while I'm traveling to Agartala, some matters in the High Court of Tripura. But be that as it may, I was listening to your delivering very nicely. Thank you very much.
One interesting aspect I may share also, that letters patent clause 15 still refers to section 107 of the Government of India Act 1915. So, yes. So, petitions that are filed under 226 or 227, power of superintendence, there is no letters patent appeal provided.
Okay.
The reason is that when power is exercised by High Court as a superintendent, there cannot be further superintendence in the form of letters patent appeal. So that is the rationale behind why a petition filed under 227 cannot be subject matter of intra-court appeal. So letters patent.
The other point that has catch my mind, my eye, or you can say, the rules which are applicable in the Gujarat High Court, especially the Rule 84 rule, then there are some other rules also. Right. Anyway, I'll have a look on all these things. Perhaps I'll request Mr. Sharma to allow us to again listen to your whatever you have discussed today.
One thing I can do is that I will share my material so that it will give you clear insight. Whatever. Sure. So that would be helpful too. I will share with Mr. Keshav.
Yes.
the short notes which I have prepared for this today's discussion. So I will share it. So that will
Sure.
be sufficient, I think.
I'll be very grateful. Thank you.
Sure, sure.
Thank you.
Thank you. Thank
Just
you.
one question, sir, with your
Yeah.
permission.
Yes, sure, sure.
So, in a Delhi family court matter,
Right.
I was for the respondent wife. My defense was struck off. And this was, I'm talking about almost 4, 5, 6 years back when I was doing this case. And I moved Delhi High Court under 227 in a petition to restore that defense and allow me to proceed with the matrimonial trial. So, although I could have moved an application for restoration or instead I moved under 227. So at that time, I was not too sure whether the remedy that I was exercising is correct or not. But I would like you to throw some light, just some insightful light on
Yes.
whether my approach was correct in doing that, because that petition was allowed by the High Court.
Yes. I followed. See, first of all, why did you choose 227? That would be a question. So that would be very meaningful all the audience. Why did you choose 227 and why not 226 certiorari, writ in the nature of certiorari, or
So
prohibition of something?
I'll give you my response. So because it's a supervisory jurisdiction,
right,
and any patent error of law jurisdiction can be cured in that. So that was my understanding at that time. So I thought maybe the High Court in its exercise under in its supervisory jurisdiction can do this. And I had found some case laws, but somehow I was not convinced. So today that now you're here, I'm putting my doubts.
Let me just point out that what you did is correct. You approached the High Court under Article 227. Right, that is because of the judgment of the Honorable Supreme Court in Radheshyam versus Chavinath, which is reported in AIR 2015. So earlier we used to approach High Court under Article 226 of the Constitution of India, because it's a very wide power. It can issue directions, order, writs, and including writs in the nature of certiorari. So certiorari is always meant to correct errors apparent on the face of the record. So you can approach the High Court under 226, and wherever intra-court appeal is there, as soon as you file 227, you cannot file intra-court appeal.
Correct.
So our always endeavor to see that party may not have to approach Supreme Court of India for appeal if we lose in the first round. So we always brand our petition under Article 226, and we will not take recourse of 227. But this intra-court appeal business continued for all these years, whether it is a 226 petition or 227 or both combined, all those things. So there was a very well-known judgment in Umaji versus Radhika Bai, which is reported in AIR 1986, Supreme Court, page 1272, wherein it was said that it is party's choice whether it would like to invoke 226 or 227. And therefore, if he has invoked both, what kind of jurisdiction was exercised by the High Court will have to be seen. And you cannot simply say that once 227 is there, intra-court letters patent appeal will not be maintainable. You cannot say that. It is party's choice.
Right.
But now, passage of time, so many controversies arose. And finally, this controversy was set at rest in Radheshyam versus Chavinath's case. Supreme Court has made it clear that once you are coming before the High Court against the order of the subordinate courts exercising civil jurisdiction, then it cannot be 226 jurisdiction. It has to be 227 only. Now, I don't understand why I am very critical about this judgment. I have actually written an article on this, that judgment is not correct law, because originally certiorari was meant to correct the errors apparent on the face of the record of the trial court, subordinate courts, but by virtue of coming into force the quasi-judicial bodies and tribunal, certiorari jurisdiction was extended to examine the legality and validity of the orders by quasi-judicial authorities or tribunal also. So that was an extension, but original purpose was to supervise or examine the orders of the subordinate courts. So now, how do you exclude 226 and confine it to 227? Because 227 jurisdiction is very narrow.
Yes.
And it can be applied only when the court has exceeded its jurisdiction. So it's again very, very long debate, but I am not taking much of your time, but what you did is rightly, you did it rightly, but you ought to have first examined this Radhesham versus Chabina, then only you should have filed 227 petition. That would have been a better thing.
Right.
But possibly somebody might have said that don't file petition under 226 because these issues might crop up.
Correct. Correct. Thank you so much. Thank you. Thank you. I'll look into this.
Sure.
Thank you, sir.
So there's another question from Nitin Pandya. He's also an advocate, very young advocate at Delhi High Court, Supreme Court. Also, Nitinji, please.
I'm audible?
Yes.
Yes.
Sir, I just want to ask that in case of emergency, but it is imposed by the government, why Article 226 is invoked and other Article 52 is stopped? So my question is that in case of emergency, why Article 226 can be invoked?
Emergency means what kind of emergency? Means constitutional emergency?
Constitutional emergency. That is imposed by the Indira Gandhi case.
No, it can be definitely invoked. Sometimes, see, in the past, what had happened during emergency, the fundamental rights came to be suspended. And therefore, the issue arose whether parties can approach High Court under Article 226 for enforcement of fundamental rights because they themselves are suspended. So, so even Article 32 would not be applicable in such cases. That's why that ADM Jabalpur's case and all those things. But prior there to very important judgment of the Supreme Court, I think it is of 1966 judgment, Makhan Singh Tasarika's judgment, wherein it was said that similar issue arose whether when fundamental rights are suspended, whether party can approach High Court under 226 by raising a grievance that principle of administrative laws were violated, that order has been passed mala fide, detention order has been passed mala fide, or on extraneous considerations, or in violation of principle of natural justice or something of that sort. The Supreme Court said that, okay, fundamental rights are suspended, but that would not preclude High Court or Supreme Court from examining the legality and validity of the detention orders on the other laws, administrative laws. So I think that's a correct judgment. And even if fundamental rights are suspended, you can approach the court for 226 petition under, and I don't think that there should be any problem.
Highly thankful for your answers. I would really obliged to your answers.
So actually, it's a very interesting question. This actually kind of leads to another question which has been put forward, sir. That what are the various kinds of rights that can be enforced under Article 227?
227 is not concerned with rights of the parties. It is concerned with the duty of the High Court to keep the subordinate courts and tribunals within the bounds of jurisdiction. So even though a petition at the instance of an individual would be maintainable, the scrutiny would be different. It would be not from the angle of the rights of the party. It would be from the angle whether tribunal has committed jurisdictional error or not, which needs to be corrected or not, whether subordinate court has resorted to a procedure unknown to law, whether that needs to be corrected or not. So party gets relief incidental. 227. I'm talking about 227.
Yes, sir.
When 226 petition is filed, it is meant for giving relief to the party. You followed us. There is a very finer distinction between nobody has done this, but there is no judgment on this. But my personal view on this 227 is that it is not my right to approach the court. I may approach it, but it is concerned with the duty of the High Court to keep the tribunals and subordinate courts within the bounds of their jurisdiction. And relief that might be given to a party or at the instance of the party, if the petition is entertained, that is merely incidental. It is not concerned with your rights at all. 227 is not concerned with your rights.
So probably we'll require a detailed session with you exploring the differences and the contours of 226 and 227.
There are subtle nuances to this, and no judgment has clearly laid out these distinctions. only two judgments. One was of Aidal Singh, full bench judgment of Allahabad High Court, I think in 1956 or 54. Aidal Singh versus State of UP. And one is Surya Dev Rai versus Ramchandra Rai, that is AIR 2003, Supreme Court 3044 most likely. So Surya Dev Rai versus Ramchandra Rai, there is a clear distinction carved out between the powers under 226 and 227. But what I am saying is still not reflected in any judgment. But you would, by your common sense, you would appreciate this distinction. That we are not concerned, 227 is concerned with the superintendent's power. The rights of the parties are subordinate. They are not at all relevant. Whether trial court or tribunal has committed any manifest error on the record.
So, sir, in this slide itself, there's another question which has come: whether a suit will automatically abate after death of defendant or through a specific order of the court only.
No, it will not require. See, once you have filed a suit and one party dies, and if you do not bring legal heirs or legal representatives within a period of 90 days, that is the limitation prescribed for bringing legal heirs, it automatically stands abated. Sometimes it so happens that you are not aware of the death of the party. Then in that event, it is the CPC casts duty on the advocate concerned. Suppose you are appearing for the defendant, to bring it to the knowledge of the plaintiff that this defendant has died. So you bring necessary application for bringing heirs. So that duty is cast under CPC upon the concerned party who is representing the person who is dead. But suppose both the parties are oblivious of the death, then you can say it was not within the knowledge. And therefore, though technically the suit stands abated automatically, it does not require any order. It's a legal, by operation of law, it stands abated. So we will have to file an application for condonation of delays for setting aside abatement, saying that the parties were unaware of the death of the party, and therefore the delay is merely technical, but I have approached within time. So just condone the delay and set aside the abatement.
And so if the condonation of delay, let's assume, is not filed, and only they file an application for implement probably at a later stage in the course of the proceedings.
No, registry will take objection that it is not filed within the limitation. So
let's assume that at a district court level. So I'll try to bring in the Article 226 and 227 jurisdiction also. But for your evaluation, that let's assume at a district court level, such and such thing has happened, no registry, nothing at all. Or judge directly he says that okay, such and such orders are passed, and they implead after date, after time.
Then that would be nullity. That order you can challenge again under Article 227. Because of that judgment, Radheshyam versus Chabinath has now virtually put a seal on petition under Article 226. So you cannot file whenever it is from subordinate court. Still, the matter arising out of tribunal, whether you can file under 226 or it could be under 227. So there is no rationale in Radheshyam that you are including subordinate courts, but 227 refers to subordinate courts and tribunal also. So you say that 226 petition will be maintainable against the order of the tribunal, but you are saying that it will not be available in subordinate court. How do you justify this distinction? So court has not given clear answer to this. So you will have to say that this order has been passed without condonation of delay, and therefore it is nullity. It has no substance in the eye of law, and therefore the trial court has committed jurisdictional error in entertaining a petition without setting aside abatement and without condoning the delay.
So one final question, sir.
Yes.
From my end, sir. What exactly are the kind of things that should be kept in mind by any advocate when moving the High Court under Article 226 of the Constitution?
See, you have to clearly understand whenever a client approaches you, you must be very clear as to what kind of order you are challenging. Because the power, as I said, that it's a power of judicial review, though it is described as writ jurisdiction, but better expression is it's a power of judicial review. Now, judicial review of what? Judicial review of administrative decision. Secondly, judicial review of a legislative act. you are challenging the virus of the act. Judicial review of subordinate legislation. Sometimes rules travel beyond the act, sometimes rules violate fundamental rights. So judicial review of subordinate legislation, judicial review in the contractual field, tender matter, contract matter, then judicial review of the constitutional amendment. So on what ground you are entitled to challenge constitutional amendment? Only basic structure. If you challenge the legislative act, then it can be challenged on the violation of fundamental rights. And now manifest arbitrariness is also part of challenge, which can be permitted. Earlier it was not possible, but now Shaira Bano's judgment, Justice Nariman has opened this issue that you can challenge even enactment on the ground that it is manifestly arbitrary. Subordinate legislation, you can challenge it being ultra vires the parent act. That is additional ground available. And administrative decision you can challenge on the ground of Wednesbury principles of unreasonableness. So that Wednesbury principle of unreasonableness word has been derived from the very celebrated judgment in Associated Provincial Picture House versus Wednesbury Corporation, which is reported in 1948, King's Bench, page 223. So only on reasonable Wednesbury unreasonableness administrative decision can be challenged. And now proportionality is also part of administrative law. So when a person approaches you, you must be clear that what kind of order you are challenging, and your petition must contain grounds corresponding to what I have explained to you. And you must mention a ground that, okay, if you are challenging administrative decision, then you have to say that it is based on extraneous consideration. It is mala fide. The decision has been taken in violation of principle of natural justice. I have not been provided with certain details. And lastly, it is disproportionate. So several punishment is possible, but the authority has not applied its mind to apply most restrictive choice. That is again a new jurisprudence which has been evolved. So once you are clear, your petition will be in conformity. When you are challenging legislative action, your petition must contain certain averments, that how Article 14 is violated or how Article 19 is violated, how restriction is unreasonable on fundamental right, means all those things.
So truly very, how do I say so? I'm sure that everyone is taking notes. And as far as I am concerned, I will go through the lecture once again, which I have always done with your classes, sir.
Sure.
So I think Mr. V.B. Sharma, sir, also wanted to ask a question.
Sure, please.
V.B. sir, namaskar. He had actually unmuted. So VP sir is also, sir, he's a former district judge from Madhya Pradesh.
Okay.
Also one of our mentors and guides.
Okay.
And though I think that probably there's an issue because he unmuted himself some time ago. Nitinji, your hand is still up. Is there anything that you want to ask, sir, further?
There are no questions. I'm satisfied with the answers which the sir has given just right now.
So that's actually fantastic because I know that what I have heard, I want to go through all of that over once again, at least. That's what.
Exactly.
And so it's always fantastic.
We are really thankful to sir. It's a really fantastic session there. And thankful to Keshav who used to give guidance in on every Sunday.
Thank you very much.
All thanks to sir. All thanks to sir. So it is always, how do I say, so enlightening and so empowering to be speaking with you. And so, on behalf of all of our team and all of our participants, I thank you very deeply, very humbly, sir. And as was suggested by Kinta sir also, that hopefully we'll have another occasion to discuss again the various contours of Article 256 and 257.
Sure, definitely.
So VV sir is also here. VV sir, sir namaskar. तो VV सर आपकी तरफ से आवाज आ रही है हमें, आप अनम्यूट है.
हेलो,
जी सर आपकी आवाज
आ रही है?
जी सर
हेलो।
जी सर आपकी आवाज आ रही है सर।
बहुत अच्छा सब्जेक्ट था, बहुत अच्छा लेक्चर हुआ है और सर ने बहुत ही अच्छे से एक्सप्लेन किया है 226, 227 आर्टिकल को, 141 और 142 आर्टिकल आल्सो। बहुत अच्छा लगा, ये मेरा क्लियर नहीं था, क्लियर हो गया आज।
थैंक यू। थैंक यू।
तो सर आपकी ब्लेसिंग्स के साथ, असीम सर की ब्लेसिंग्स के साथ एंड हमारे जितने पार्टिसिपेंट्स जो ज्वाइन कर पाए हैं, सबकी तरफ से सर को बहुत बहुत हमारी तरफ से शुक्रिया अदा। असीम सर इज आल्सो sir, is it correct if I say that you are also supporter of regional languages being promoted in high court jurisdictions?
Yes, I have filed already a petition saying that regional language should be permitted in addition to English. I am not saying that it should be substituted, but it should be permitted as an additional language, because when we are celebrating Azadi Ka Amrut Mahotsav, we should come out of this colonial mindset also. I am not against English. I love English language, but for people of India, it should be, high court proceedings should be permitted to be in regional languages also.
So again, sir, it's a very how would I say, it's a very deeply touching topic to me personally, and I think litigation also has.
I just want to ask something.
Yes, sir.
What is the result of that petition in the High Court?
The courts have not yet issued notice, though they have heard me for about 1 hour. But court is in dilemma because the proposal of the governor was rejected long back in 2012 or 2014 by the Supreme Court. Supreme Court has rejected proposal of Tamil Nadu, Telangana, Gujarat of adding this language. But my basic contention is this, that Supreme Court has no role to play in the matter which language should be permitted to be used, because their role has been brought indirectly by one cabinet committee resolution. There is no constitutional provision which provides consulting or taking concurrence of the Supreme Court of India. Constitution only provides that language commission and language committee should be consulted in this matter. Supreme Court has no role to play in the matter. So their rejection is outright without jurisdiction. It is based on extraneous consideration, and it is simply, they have not deliberated why it should not be done.
Okay. So I'm so sorry, sir. Please go ahead.
I think I understand. I'd like to request you once again to share your notes. Whatever you have to.
Yes, sure, definitely. I will share with Mr. Keshav and he will supply it.
हमको बहुत जानकारी मिला है, जैसा somebody said just now, बहुत जानकारी मिला है. Thank you.
Thank you. Yes, Pranav.
So just thank you, sir. The recent fact that the CJI of the Supreme Court has said that the judgments of the Supreme Court may be uploaded in regional languages also. That adds impetus to your case.
Yes, it adds impetus to my case. But basically, see, when proceedings are conducted in English, the litigants are absolutely unaware of what is happening. Absolutely. And the classic example, if you want to really understand the plight of litigant, you just read the judgment in Umaji versus Radhika Bai, AIR 1986, Supreme Court 1272, where a poor illiterate lady had approached Bombay High Court for some relief regarding her rights in the land. And the Supreme Court Justice Madan has examined the aspect of history of Bombay, how Bombay was established, Portuguese time, then what letters patents were issued by High Court, original British Crown, and beginning of the legal history he has examined, with which the poor lady was not concerned.
Right, sir.
So the judgment should be made available in regional language, and that should be confined to the controversy. You should not go beyond why who is interested in it, except academicians like me. I love that judgment for the reason that it gives a very detailed account of how courts were established in India.
Right.
But that lady, poor lady, was not concerned with it.
Yeah, absolutely. Absolutely right.
So that
so we can probably refer to the new directions given by the CGI that the fact that judgments should be uploaded in regional languages also, especially.
But who is going to read? See, nobody has time to read. What I am saying is that what is transpiring in the court must be understandable to common people.
You're talking about the proceedings also.
Yes. Proceeding. And see, in your mother tongue, you are always more fluent and you are more expressive. Right to express includes right to express effectively. So you can be better in your mother tongue always. English, of course, it is thrust upon us. But
Sir, one thing I would also like to mention, so the vice versa thing is also sometimes problematic. So in Bombay, they note the police station reports in only Marathi.
Marathi, right,
sir. So now we don't understand that much Marathi. It's a basic Marathi we know. But sir, in court we require each and every word is important. So we should get a optional of noting that in English also. Or if we apply for some RTI, they give answers only in Marathi. Or some judgments of quasi judicial authorities like BMC, or they give order only in Marathi. So option of English also should be available. So vice versa is also.
That is right. Now, because of technological advancement, everything is possible. Immediately it can be translated. You put it in Google Translate or something of that sort.
So, but entire judgment can be put on Google to translate, sir. The Google will translate your entire judgment, sir.
I think there are so many tools now available. You can explore
it. But copy and paste.
Yes. I think you will have to simply check it again. Proofreading. You will have to do proofreading so as to make it mistake free. But 80% it will be done. 80%.
Acha, it automatically translates the entire judgment if you copy and paste it.
So there are many other tools, but I understand your plight also, that this is a very larger issue. It cannot be discussed and answered in one sentence. So
because some politicians focus. No, it only should be in regional language.
It is not their focus. No, it is not their say. It should be in addition. There is no provision in the constitution which permits substitution of English. English will be there, but additional language. So there is no provision of substituting English. Constitution doesn't permit.
So but in additional, they can give a judgment in English. That's what we say.
Yes, judgments are to be in English.
Yes, sir. Which they are not giving right now. In Bombay.
Sanjeev, we'll have again a very
sure.
With sir, hopefully this is right. And sir, seems to just one final parting word, not from my words, sir, but in support of your contention only. I want to read, sir, from this is a speech by
Mahatma Gandhi. Yes.
Sir, this is in 1912.
Yes.
At Banaras Hindu University.
Right.
We will read word by word what he said, sir, just for you, and sir, in photo what has just transpired in this class. He says, sir, I had the privilege of a close conversation with some Pune professors. They assured me that every Indian youth, because he reaches his knowledge through the English language, lost at least 6 precious years of life. Multiply that by the numbers of students turned out by our schools and colleges and find out for yourself how many thousands of years have been lost to the nation.
That's right.
So this one book I found, and I was just reading this, and all of our support, all of our blessings.
Thank you.
Mission that you have undertaken, sir.
Thank you. Shall we take leave?
Absolutely, sir.
Sure.
Very good.
Bye.
Thank you so much.
Thank you, sir.